Hello and welcome back to our video series, How to Nominate a Subclass 482 Worker. In this, the final of our video series, we're going to look at what's next, moving on from the 482 visa. So your 482 visa nominee is in place, and you may want to keep them longer than the duration of the visa, or they may want to stay permanently in Australia. So let's look at the options available. The three main options to look at would be the employer nomination scheme, once again an employer-sponsored scheme, and a permanent residence version of the 482 program. General skill migration does not require employer sponsorship, and the partner visa may be available where your nominee has entered a relationship with an Australian citizen or permanent resident. Under the employer nomination scheme, the most common pathway for a 482 visa holder is via the transitional pathway, where, having completed 2 years on the 482 visa, they are nominated by their current sponsor for a permanent residence visa. The employer must be the current sponsor for the 482 visa, but note that the 482 visa holder may accumulate the 2 years with more than one employer. The employer must offer a contract for a minimum of 2 years, and the nominee must be under 45 years and meet the English requirement, which is slightly higher than it is for the 482 visa. So once your nominee has completed 2 years on a 482 visa, then they can be nominated under the transitional pathway. Some candidates may be eligible via a different pathway, still under the employer nomination stream, known as the direct entry pathway, where their occupation is on the CSOL and they meet any caveat requirements. If they have a formal skills assessment for their occupation and 3 years experience, they may be nominated for direct entry. So the direct entry is available for candidates who may not even have been sponsored on a 482 visa. But in your case, if you've nominated an employee under the 482 visa, then instead of them waiting 2 years to travel down the transitional pathway, they may be eligible earlier via the direct entry pathway. This may or may not be of interest to an employer because once the person has the permanent residence visa, it is difficult to ensure that they remain in the position, even though the employer must offer a contract for a minimum of 2 years and the visa applicant must agree to the intention to remain with the employer for that period of time. As with the transitional pathway, the visa applicant must be under 45 years and meet the English requirements. It's important for employers to know that candidates may have alternative methods of obtaining permanent residence other than being sponsored by an employer. General skill migration is a program in which a person's attributes in terms of age, English language level, qualifications, work experience overseas, work experience in Australia, partner skills, and some other attributes are all assessed and allow a candidate to participate in an expression of interest skill select program. Such a program allows the candidate to have an EOI in place for 2 years, during which time they may or may not be invited to apply for a visa. So there's some uncertainty for a candidate under the GSM program, depending on the priority level of their occupation in Australia at the time, the number of points they can achieve, and a range of other factors. Some visa holders, 482 visa holders, may enter a relationship with an Australian citizen or permanent resident, and that may give rise to them applying for a partner visa for Australia. They must be either married or in a de facto relationship, which includes either living together for 12 months or having a registered de facto relationship. The relationship must be genuine and continuing, and the Australian person must be able to sponsor by showing that they can provide food, accommodation, and clothing for the visa applicant for a period after the visa is approved. Partner visa applicants are initially granted a 2-year visa, which converts to permanent residence at the end of that period upon provision of updated evidence of the relationship. So they're not going to get permanent residence directly, and sometimes that's a factor in their consideration of whether or not to proceed via the partner visa route, or if they prefer their employer to nominate them. In considering options for your candidate, consider the longevity of the role itself and the nominee's place within your business, and whether you have a long-term plan for them to remain with you. Look at the options and communicate with your nominee early so that both parties know where you're heading, and if anything needs to be done, it could be done in plenty of time before the 482 visa expires. Moving a nominee on from the 482 visa to permanent residence opens up a whole myriad of options and criteria. And we understand that these can be confusing, as you're not migration professionals, you're business owners or specialist managers working within your own business. We're here to cover you and provide you with all the information you need. So feel free to take advantage of our free 20-minute call offer and discuss your needs and your candidate's needs with us. We also have appointments available for candidates or nominees themselves to have a private paid consultation with us to discuss all their options, which may or may not include seeking sponsorship by the employer. So talk to us first so you're in the know, and then we can help you from there. Thank you very much for joining me in this video series. I do hope it has been of benefit to you, and of course reach out so that we can help you further as you require. Thank you very much, and all the best.